Hello, everyone, and welcome to today's event on Live Nation Ticketmaster case and competition in live events. My name is Brimhall, and I'm the Federal Affairs Manager for the Tech and Innovation team at the R Street Institute. R Street is a 501c3 nonprofit, nonpartisan public policy research organization. Our mission is to engage in policy research and outreach to promote free markets and limited effective government. It's my privilege to moderate today's panel. Our panelists include Josh Withrow, fellow on the R Street Technology and Innovation team, Tirzah Duren, president of the American Consumer Institute, a think tank dedicated to using economic analysis to promote policies that enhance consumer welfare, and Kathleen Bradish, vice president and director of legal advocacy at the American Antitrust Institute. Kathleen has been an antitrust lawyer for over 20 years, including a stint as assistant chief and international counsel at the United States Department of Justice Antitrust Division. We'll be collecting questions through the Q&A function on Zoom, so please submit any questions you have during the conversation and throughout. All right, without further ado, Josh, would you mind kicking us off by teeing up the basic essentials of the case in the Live Nation Ticketmaster instance, and the consent decree and background?
Sure. So yeah, I'll take it as my role here to sort of just introduce the basic facts of this case, so that then the other two here can really start to get into the more interesting stuff, the analysis of the case going forward and all that. So just for those who don't have sort of any backgrounding on the case at all, I'll keep this really short. But what this comes back to is that back in 2009. Two of the largest companies within the live events industry, Ticketmaster and Live Nation, filed to merge. Ticketmaster at the time was by far the largest company in sort of primary ticket sales for live events. Live Nation was both one of the largest venue owners and also one of the largest sort of event promotion companies in the nation. And together, of course, obviously they formed a pretty powerful conglomerate. And so naturally, this merger got flagged for the Department of Justice to review. And the Department of Justice chose to allow the merger to go forward, largely because they considered this to be largely a vertical merger, as in, Ticketmaster had the ticketing market, Live Nation had the venues and the event promotion markets, and together it would be more of a merger of parts of the live event stack, and not as much of a what you'd consider a horizontal merger, where it was, say two of the two ticket sales companies coming together. But they did that. They allowed this, understanding that this was going to form a very large firm with a large chunk of various parts of the market. They allowed this merger to go forward only under a consent decree with certain conditions that included, for example, Ticketmaster having to sell off portions of its existing business, but also a number of behavioral conditions that the merged company would have to agree to. One of the most prominent of which was that they wouldn't use their dominance in any one layer of this live event stack to sort of coerce, other actors to purchase other parts of their business. This consent decree was a 10-year sort of probation period, and over the course of that 10 years, the Department of Justice picked up a number of instances where it found that the now merged Live Nation company had violated the terms of this consent decree. And so when the 10 years were running up, they conducted a review and determined that since the conditions of the consent decree weren't being weren't being followed, they took the unusual step of extending the consent decree for an additional 5 years. This is normally not done. And then towards the end of to 2024, with that extended consent decree running out, finally the Department of Justice actually filed an antitrust complaint formally, sort of challenging the merged company for having, one, violated its consent decree, and also having illegally behaved anti-competitively and illegally monopolized various parts of the large event market. It's a pretty broad, ambitious case in that it alleges monopolization or anti-competitive behavior on like a half dozen different layers of the live event stack. And it particularly focuses on Live Nation's control of large event venues and arenas, because Live Nation owns 64% of the largest concert and event venues in the US, whereas Ticketmaster is the sole primary ticket vendor for 82% of those large venues. And while there's nothing inherently wrong under antitrust laws with like offering product bundles or like discounts for bundled products. What Live Nation stands accused of doing is conditioning contracts with venues, contracts with artists on using other parts of its stack. Basically saying, if you don't use Ticketmaster, maybe we don't offer our concerts at your venue. Things like that. Um, and it's particularly noteworthy, sort of how red-handed they've been caught doing this kind of coordination in this case. And so that's one of the reasons why there comes a point when even as a very sort of laissez-faire free market group, I come to this as working in antitrust and examine this case and the specific allegations that are being made here and go, well, if there's ever a time to apply antitrust remedies to anti-competitive conduct in a market, this is a pretty egregious example. And so, that's sort of what motivated our street's interest in the case, is that this is one of the more sort of glaring examples of where antitrust intervention into the market is probably just necessary in order to solve harms that are clearly causing problems for consumers in the forms of ticket prices, in terms of availability, in terms of the quality of the products that are available to them on the market. And so that's sort of the basic background of why we're interested in the case, and that's sort of where we're at today, because the case is going to be a slow moving one, but we're finally getting to the point where the beginnings of a antitrust trial will be taking place towards the beginning of the new year. The judge in the case hasn't set a date yet, but said that he expects that the initial trial will commence sometime in the spring of 2026, and then we'll start seeing whether the case holds water and how far it might go.
Thank you, Josh. I appreciate that. I also want to give a chance to our other panelists to jump in and provide any other details that Josh may have missed, or just things that you'd like to emphasize. Kathleen, would you like to go first?
Sure. I think it's worth spending a minute talking about why this should matter to our audience and really basically to all consumers out there. Who should worry about this case? I think if you are one of the 141 million people annually who attend concerts, you should care about this case. And you should care about it even if you're a music lover who doesn't have the means to attend live events today. This is because Live Nation's monopolistic conduct, as alleged in the DOJ case, hurts every aspect of the music and live entertainment industries. In response to recent scrutiny, the company has tried to downplay, and that's really one of its big PR pushes, is to downplay its outsized role in live entertainment. It says that it doesn't have a primary role in setting ticket prices, for example, or that bots are partly to blame for its technical failures, and even claim that the company is barely profitable. But at the end of the day, this distracts and deflects responsibility for the real consumer harms the company's conduct causes. So I just want to pause a minute over what those are. The first and most obvious harm here is higher ticketing fees. Those service fees, convenience fees, and other add-ons you've seen in your online cart when you go to complete your concert ticket purchase. The DOJ's complaint aptly calls these the Ticketmaster tax. When one company like Ticketmaster Live Nation has an entrenched 80% share of the primary ticket sales, as Ticketmaster has for more than a decade, it's just a truth of the market that it lacks the competition that would keep such fees in check. The second harm that is equally important is that when you have a monopolist like this that is illegally abusing its monopoly position, illegally extending its monopoly position, consumers lose out on quality and innovation. Without competitive pressure, a company with the market share that Live Nation has can force its customers quite simply to settle for less. The Senate Judiciary Committee hearings back in 2023 followed large-scale failures of the Ticketmaster platform that I think everybody is aware of during the ticket sales for Taylor Swift's Eras Tour. The fans then expressed their disappointment loudly and often. They blanketed social media with their complaints. Yet, instead of focusing on improvements to customer experience, Live Nation deflected its responsibility onto so-called bots. This, frankly, is how a monopolist acts. Companies worried about losing business don't cast blame or point fingers. They quickly correct mistakes and, more importantly, find ways to avoid disappointing consumers in the first place. If they don't, their competitors would soon take their place with better and more reliable options. Finally, another important harm is that Live Nation's grip on live entertainment means consumers have less access to artists they already love and fewer opportunities to discover new artists. According to the DOJ, Live Nation has control over more than 70% of concert promotions for large amphitheaters in the US. Artists who do not use Live Nation for promotion can find themselves locked out of these venues. And smaller artists in particular find it harder and more costly to make the jump from small venues to the wider audience they can reach by touring large amphitheaters. We saw this in some of the testimony at the Senate Judiciary Committee, where singer-songwriter Clive Lawrence testified movingly about the obstacles that Live Nation's monopoly creates for artists who are on the cusp of a broader audience success. So these are the things that are at stake, and I think these are things we have to keep in mind as we discuss the repeated and entrenched behavior that Live Nation has engaged in, and also as we talk about the remedies that are appropriate in this case.
Thank you, Kathleen. Tirzah, anything that you would like to add before we dive into more of the conversation?
Yes, I agree with everything that's already been said. But there are a couple very interesting parts of this that I think are worth kind of pointing out and keeping in mind. The first one is that when you look at a lot of the DOJ's complaints, specifically in the 2024 complaint, we don't have the situation of the unknown counterfactual. In this situation, we can look back at 2010, see there's a lot of parallels in the two complaints, and we can kind of very clearly see, okay, we know how Live Nation and Ticketmaster will act because they've been doing it for the past 15 years. This is kind of a unique case in this sense that they were given a chance to act legally and above board, and we saw them fail to do that. And so I think that's one thing that's really interesting to keep in mind. Another thing that always piques my interest, and so I'd like to get everyone's thoughts on it further on in the conversation, is that they were briefly ticketing competitors for a matter of months, and then they announced their merger. And I think that's also a really unique aspect of this case that maybe I'm more interested in it than other people, but I think it's really interesting. And then the second thing just to keep in mind in this conversation is really the broader question of who is the consumer. And I think when you're talking with the full vertical stack of a lot of the live entertainment ecosystem, you have the end consumer, right? The person who's purchasing the tickets. But you also have the consumers at each individual point of the system. That could be venues and that could be artists. And I think keeping that in mind when you're looking at this case, that there are a bunch of different consumers to consider, as well as the ultimate downstream consumer, is really helpful.
Thank you, Tirzah. Okay, now I want to dig into a couple of questions that I had. Kathleen, if you wouldn't mind starting us off, do you think that the case brought by the DOJ is solid under US antitrust laws? And would you expect it to succeed?
Yes, absolutely. So I will just state at the outset that this has already been tested to a certain extent. There was a partial motion to dismiss filed by Live Nation, and it was completely unsuccessful. The court said that the claims were solid from an allegation perspective. Now, of course, we haven't seen the evidence yet, but as far as the kind of allegations that the DOJ put forward, and I will also add there are 30 states involved too, so it's not just the DOJ. It has been tested, and the judge in the Southern District of New York has vindicated the allegations. So I think the DOJ is on solid footing going into the trial itself. I think these are not these are solidly within the kinds of Section 2 claims we've seen. Section 2 claims aren't that frequent, although, since in the past couple of years, they've become much more common under the, starting with the last Trump DOJ through Biden and now in this Trump administration, the willingness to bring Section 2 cases has gone up considerably. But, there's nothing that I see here that's a stretch under the US antitrust laws. We see very classic allegations, long-term exclusive contracts, tying allegations. We see conduct that looks very suspicious. We already talked a bit about the fact that there was, and at the stage of the merger, an overlap between Ticketmaster and Live Nation on ticketing. And in this case, we see a repeat of that conduct in some ways with this, what the DOJ calls a competitor turned partner Oakview Group, where the allegations are that it was pressured into not competing. And that is a classic antitrust violation. So I think we're talking about very defensible, very traditional in many ways antitrust claims under Section 2.
Thank you. And Tirzah, I wanted to also pose a similar question to you. Would you agree that even from a free market consumer welfare perspective, the DOJ's case seems to make sense?
Yes, and I think just to kind of reiterate what Josh said earlier, it is interesting to read this case because American Consumer Institute, we do come from the consumer angle and we tend to take more of a free market approach. But when you're reading through it, it does seem very straightforward, very clear. And for a lot of the allegations, the evidence is also pretty convincing in the form of direct email stating exactly what they were going to do. So there wasn't a lot of reading between the lines for a lot of this situation. And so I think from a free market perspective, it does make a lot of sense. And also there is potentially a theoretical landscape where the vertical integration could have been used to create consumer value, having a one-stop shop for your concerting, ticketing, all that stuff. Theoretically, it could have been good, but I think what you see is that there has been coercion. And instead of kind of competing through increased value to kind of build a business and brand that way, we've seen a lot of the direct coercion. And that's, I think, pretty straightforward and something that people from both sides of the spectrum, free market or not, can kind of get behind.
Gotcha. Josh, anything that you wanted to add on the validity of the case?
Yeah, really. I mean, just agreeing with both Tirzah and Kathleen on this. The thing that sort of is interesting to me is a sort of philosophical abstract matter is, one of the bigger debates in sort of how to enforce like Section 2 cases into things like tying is to what extent you can consider tying to be coercion, and where you draw the line on that is not always super clear either from the perspective of economics or policy. And so it can make it very difficult to prosecute these cases at times because, does the company being big in this one part of the market necessarily mean it's coercive if it tries to bundle products, for example? But in this case, you don't even have to ask that question because we have them in email communications straight up admitting that, like these communications with Oakview Group, that, they're using a potential competitor in the market as sort of a bludgeon against, to coerce, for example, venues into accepting their artists and their promotion. It's so rare that it's this straightforward of a case, and so that makes, it makes it pretty easy to move forward.
Thank you. I appreciate that. And yeah, I guess since we agree on that point, my next question would be, the judge raised questions about the market definitions that the DOJ presented. Do you think that the DOJ's expansive claim of market dominance across all of these different vertical components of the live event market will hold in court? And I open that to everyone, but maybe Kathleen, since I heard from you last, we'll start with you.
Yeah, so I think at the end of the day, the documents that a business has on there's lots of economic tests and lots of ways in which you can show market definition. But from a practical perspective, sometimes and you see this, for example, in the case involving handbags with Coach and this accessible luxury market, that this is an FTC case. When the documents of the company confirm that this is how they see the market, that's pretty convincing, regardless of economic models or in support of economic models, generally speaking. But that's really smoking gun evidence to me. And then simply, when there's anti-competitive effect, that tells you the market definition is right. So I think we see that here too.
Tirzah, anything you'd like to add?
Yes, I'd like to just note I agree, and I love the reference to the Coach handbag case. I like that one. But in the 2010 complaint, I think what's notable is that the market definition that they really focused on was the ticketing services. And in this complaint, they've really built a case that I think is very illustrative of how the different power at different parts along the ticketing infrastructure is feeding into each other. And they call it obviously the Ticketmaster Live Nation flywheel. And so I think if you're going to make your case about your harm and your mechanisms of harm being kind of at different points along this entire chain, I think that the relevant markets have to either say it's the entire live event entertainment space, I guess. Maybe that one would be one, but it seems kind of broad. But I think it's almost a necessity to be able to include it in these, have the different relevant markets that hit the different parts that you're actually talking about. I don't read the tea leaves or anything like that. I think one of my concerns with having the different ones is that maybe it would be easier to get one or two of them thrown out. But again, I think when you read their case, when you read the harms that they're alleging, that having those different relevant markets makes a lot of sense.
Josh, anything from you?
Yeah, the only thing I'd briefly add to that is that, yeah, it certainly from like the classical, if you were just analyzing one of these markets at a time, as opposed to the whole flywheel, which going back to what Kathleen said, that the flywheel that Tirzah mentioned is actually terminology from Live Nation's own documents. They talk about the fact that they use the event promotion and artist representation and live event ownership and ticket sales. The fact that they own parts of all of these, they can use the large profits they get, for example, from the primary ticket sales to sort of subsidize then their increased positions in the markets further up and down the stack. The interesting thing in terms of the remedies is sort of like in a classic market definition battle where you're trying to establish whether or not somebody has what you'd consider to be a monopolistic position. It's much easier to do that in the primary ticketing market, where Ticketmaster has had a durable 70+% share of that market for decades. I mean, even going back before they merged with Live Nation. Whereas if you were just to take some of these other segments alone, you could make the argument, I'm sure that Live Nation will, that they have large shares of these markets, but they aren't what would count as monopolistic in and of themselves. So the question is whether the DOJ can compellingly make the case that taken as a whole, even though they may only have like a 50% position in, say the X or Y market, taken as a whole, it still constitutes essentially monopoly power or anti-competitive power. Because of their dominance in one or two of the other shares, and that's going to have interesting implications on sort of how far the DOJ can go in searching for remedies if and when the courts decide in their favor in the case. I'll be kind of curious as to opinions because I'm sure we're going to get into potential remedies and what's sufficient and what's necessary. What you think they're going to be able to get out of this.
Yeah, I do want to definitely get into some of the remedies discussion. Before we transition to that, though, I do want to emphasize or pick out that it seems pretty clear from what you guys are saying that there's a lot of evidence, a smoking gun of kind of the misbehavior of these organizations, and in particular in violating the consent decrees, the decree that they've been put under. With that in mind, how much do market definitions matter? Anyone who wants to jump in, but I'm going to default to Kathleen and do my rounds to make sure she gets to talk, because I think she's got a lot to say.
Um, yeah, so I think, when you look in general at court opinions, there is an argument and a good argument that you should look at the anti-competitive effect, and that when you see the anti-competitive effect, the details of looking at market definition maybe matter less than when the anti-competitive effect isn't there staring you in the face. But as a general rule, I think courts feel much more comfortable if they can do a very traditional relevant market analysis. I think we would expect, they still, I have yet to see an opinion or one that comes to mind right now that doesn't talk about brown shoe and the traditional factors of market definition. So again, as a practical matter, I think we're going to see that. But in there is still a strong argument that do you really is the dish already cooked, because we already know what the end game was and is in this case.
Yeah, when you have the company themselves referring it to a flywheel, that does seem like a bit of an issue. Tirzah, anything you'd like to add there?
Yes, just to echo, I think the relevant markets are a pretty foundational aspect of the complaint and of the case. And so I think they do still matter, because that is the realm in which you're saying this harm happens. I think that this is also kind of a unique case in the sense as we had the previous complaint, we had the consent decree. The consent decree didn't do what it was supposed to do. And then we have a lot of evidence of the companies basically saying exactly what the DOJ laid out in its complaint. And so I think the relevant market still matters. I think it's something to consider and something to think about, but I don't necessarily think it's going to make or break any of the decisions.
Josh?
Only thing I'll add to that is that, just to go back to what I think both Kathleen and Tirzah mentioned earlier, is that, we're basing these judgments on our part based on only the evidence that the DOJ was willing to put outright in its complaint. We don't even know everything that's going to come out when this thing goes to trial, and so that's probably a pretty bad sign for Live Nation.
Okay, good note. All right, so now I do want to transition a little bit if we can. So even if we all agree that Live Nation Ticketmaster clearly broke the law, is unwinding the merger a given? Should the DOJ case prevail, what would be an alternative remedy? And again, I'll open that to the group. I feel bad always picking on Kathleen first, but I'd love to have you answer that if you don't mind.
Yeah. So I think we see in the complaint and in what DOJ is asking for in the complaint, really thinking hard about what the remedies should be here, and that they're really starting from the remedy and working back, which is, I think, what you need to do in a Section 2 case, because you can win the case on liability and lose the case on remedy. And that will be the death knell for its effectiveness if you can't get the remedy that works. So in this case, I think, again, there's a classic example here of a company that has shown that it's willing to go around behavioral remedies, that it's willing, when the consent decree in the first consent decree at the time of the merger was basically a list of behavioral commitments that Live Nation Ticketmaster clearly went around, if not outright ignored. And when the consent decree was renewed, there was discussion about, how to interpret some of those commitments, and Live Nation took a very creative interpretation, shall we say, of what these commitments were, in order to try to argue that it had honored them. And simply the fact that we keep coming back, and despite these commitments, we keep coming back to many of the same issues over and over again. I think that's a classic instance in which you need to ramp up the remedy. Simply doing the same thing over and over again, insisting on behavioral commitments that a company has already shown it's willing to bend and break, is Sisyphean.
Yes, well said.
Yeah. So I think that's where we are now, and I think it's part of this, the canon to say that this is the point at which you look at structural remedies, because only structural remedies address the incentives and eliminate the incentives, for example, for tying and other kinds of, I guess, the flywheel abuses, is if you separate out. And in a case where you have a remedy, where you have a merger, where you have an acquisition that created the opportunity for some of those abuses, it does seem particularly apt to look for a structural remedy.
All right, I know that my other panelists here are a little skeptical of structural remedies in general, but I want to get your take on this. Tirzah, what do you think?
I think in this case, it does make a lot more sense, specifically compared to other cases that it's brought about. I do have some concern with structural remedies, not necessarily in principle in this case, but as far as efficacy in this case. I think my concern is, okay, so you have Live Nation and Ticketmaster, so now they're going to be separate entities. And I think we've seen both of the companies' willingness to kind of skirt around some rules. What if it becomes kind of an Oak Group situation where, yeah, they're technically separate, but they're not really driving each other to compete anyways? I guess on a more optimistic front, Live Nation had a very brief ticketing platform. Maybe they resurrect that and then you have a more competitive environment. That could be really great. But I think that the structural remedies makes a lot of sense in this case. I also wonder how you can create it in a way where you don't end up with people de facto deciding to cooperate instead of compete, even if they are technically two separate entities. And so, yeah, that's the main thoughts on that. And then I think there's a lot with the ecosystem in general, where even breaking up Ticketmaster isn't going to solve everything. But to answer your very specific question, yes, I think it makes sense.
Yeah, and I do want to dig a little bit more into how successful these will be. But first, I do want to make sure I get Josh's perspective on this, and whether or not you think that unwinding the merger is a given, and is that the most appropriate remedy?
Yeah, I think I agree with. Well, once again, we agree on a lot of things here up to this point. In that, I think when you have a pattern of behavior, a pattern of consistent noncompliance, that's when I'm hesitant to just go right into a first offender and say we're just going to break up your company as the sort of initial remedy for anti-competitive behavior. But in this case, we have a pattern of behavior, based on a consent decree that was conditional for even allowing this merger to happen. That has been just repeatedly ignored. And one of the things that I would love to see is I definitely advocate for a much more sort of permissive market with respect to allowing mergers, perhaps than a lot of antitrust reformers would. But one of the only ways that works is if there is an understanding that that there's sort of a culture of compliance that companies know there's certain lines they shouldn't cross. And so sometimes in the case of an egregious offender like this, it's not like, yeah, you can fine a company and you can get treble damages and all that kind of stuff in an antitrust case. But sometimes to quote to quote the Dark Knight, it's not about the money, it's about sending a message. Right. And I hate to be that crude, but it's there's something to that, in that, if a company is allowed to get away with this egregious of a just defiance of the legal conditions of merger operations and antitrust law, then it potentially sets an example for others to follow. And that's not a good precedent to set, even if your general position is that we should allow most mergers.
Yeah, I appreciate that. I also appreciate the Dark Knight reference. I always love a good nerdy quote. Okay, it sounds like we agree that Live Nation, Ticketmaster, they've done some things that violate the consent decree. They gave good reason for the DOJ to bring this case against them. It might even make sense in this specific instance to break up the organization because of the history and continued, abuses that they've kind of performed under these behavioral style agreements that we would normally, hope would be sufficient in order to address the behavior without kind of that breakup being necessary. So assuming that breaking up the merger is in the cards, how much can we expect this will actually solve the problems most consumers perceive with the ticketing industry? And this is really building off of what Tirzah was, I think, already alluding to. So Tirzah, I don't know if there's anything else you wanted to add to that to kick us into that next part of the conversation.
Yes.
Yeah.
So I know I sounded optimistic with Live Nation resurrecting their ticketing platform. So I'll backtrack and become the pessimist now. I think that Ticketmaster, Live Nation, that ecosystem is a huge component that stopped a lot of competition and innovation within the live entertainment space. I think there's other things that we also have to look at. And I mean, not to bring up Taylor Swift, but she does seem kind of pertinent to this specific case. Um, sh- Obviously, Live Nation did not handle that ticketing well. And there was lack of access, there was crazy high cost, people were frustrated. And I think it's really easy to look at Live Nation and be like, this is their fault. But there's the other flip side of it, which is those tickets were probably going to be insanely expensive because it's the Taylor Swift Eras Tour and her fandom will apparently like take out a second mortgage on the house in order to see this event. I did not go, so I can't actually speak to whether or not it's a worthwhile investment. But I think the high cost of tickets is what a lot of people from the downstream end consumer ticket purchasing see as a huge problem within the live event space. And I think that there is a simple supply and demand for a lot of these shows that increase the cost of these tickets. And that's not necessarily going to be solved by breaking up Live Nation and Ticketmaster. And so I think it's going to help the ecosystem. It might help the process. I have no idea what innovation might kind of calm down and blossom in the vacancy that it's left, but I do think we should be a little bit cautious when saying that it's going to like make all this more accessible or make it more affordable, where we have kind of emerging trends where there's a split of artists. There's kind of the ones that can do the big large tours, make all that money. You have the Beyoncés, Taylor Swifts, and I don't know who else kids are into these days. But then you kind of have everybody else, and they're not really going to be driving those tickets. And so maybe it'll help affordability on that side. But I think looking at it just from prices, I don't know if consumers are going to kind of be like, check, we're done, everything's solved.
Yeah, that's a great point. Obviously, the demand for Taylor Swift is much higher than the supply. No matter how big a stadium she performs in, there will always be more people who want to go than tickets available, it seems. Kathleen, did you want to contribute to this question as well?
Yeah. So I think one of the things to keep in mind, we've been talking about whether the breaking up, a breakup remedy is enough here, or if that's going to solve all the problems. And I think one of the things to keep in mind is part of what a remedy needs to do to be effective is to look forward. It can't just look back. and undo what happened previously or address the conduct that's already happened. It has to foresee what conduct might happen. And I think that's important. That's an issue, for example, in the Google search case in discussions about AI, for example. We can talk about search monopolies, but are we really addressing it if we don't also address AI? So the analog here might be, what about secondary ticket markets that are involved here? What about the mobile space for ticketing? There's any number of possibilities here, but the orientation has to be a future orientation if the remedy is going to be effective. And that may demand going beyond a simple or just a straightforward breakup. You also have to consider how the other ways in which the monopoly might continue or shift and reassert itself, and try to address those too.
Gotcha. Josh?
Yeah, totally agreed. When I was, I wrote a paper for R Street on this case, and sort of the thing I was focusing on was really sort of just taking for granted that this case is solid enough that, say the DOJ wins it and it breaks up Ticketmaster, how much will that actually fix? And if it doesn't fix the market, what else might be necessary in order to actually, further, ensure a competitive market that actually works for consumers at various levels of the stack, the artists, the venues, the consumers, and it gets messy. This is probably finally the portion of the panel where we'll hit points where we disagree. But it's also because there aren't easy answers necessarily, and so there's also questions of how much of this can be done through the remedies in this antitrust case, and how much is going to be necessary to also do an addition through Congress, as dysfunctional as it is, or maybe even in some cases at the state level. And so there are certainly some potential fixes out there that I would favor over others. I think obviously simple things like limiting the terms on exclusive contracts that Ticketmaster can sign with the venues is probably reasonable at this point. It may very well be that some of these venues decide that Ticketmaster is still the best primary ticket provider and decides to sign up with them anyway, but not allowing them to lock them into 10 or 14-year long exclusive contracts is probably a good idea given their behavior at this point. And then beyond that, you start to get into things that I think you really need legislation to address, and there are various bills that have been proposed at the federal and state levels to try to do this. There's the Tickets Act that I believe passed the House actually already this year and has been sort of sitting in congressional limbo, and that has a lot of transparency provisions in it that try to address things like try to stop the sale of fraudulent the second party tickets, and try to make sure that like prices are transparently listed up front, and certain other sort of consumer protections like that in some cases might make sense. And then there are other proposals, particularly at the state level, that I think we should stay away from. Like there have been a number of states that have tried to propose just outright capping prices in secondary ticket markets, like saying you can't resell a ticket that you buy for more than 10% of what you bought it for. That's an approach, I think that's a pretty blunt force trauma approach that I think we've tended to see how price caps backfire in almost every other part of the market where they're applied. And I personally would say that should be a no-go. Like the District of Columbia is actually the latest state and territory that's considering a bill to do just that, and that would be, I think a disaster. But yeah, there are problems inherent to the market, as others have discussed here, that are not necessarily easy to remedy either via antitrust action or the legislation. And so it leaves an open question of where you draw the line on intervening, because you have the problem that artists don't want to be seen as the bad guys, and so they very often will not set ticket prices near what the market will actually bear. They'd rather sort of the blame for higher ticket prices get borne by venues, by Ticketmaster, by scalpers. And you have also simple supply and demand issues, especially with some of these large venue, sellout sort of acts like like a Taylor Swift, that are very difficult to solve, without sort of increasing the supply of seats, of venues. There are efficiencies that can be created by getting rid of some of the problems that exist with the secondary market, like trying to crack down on bots, for example. But I don't know. That's a long, messy answer to say that as soon as you get into the solutions side of this argument, it becomes really, really messy to figure out what a competitive market really ought to look like. And hopefully, in a world where the DOJ comes in and undoes this merger and maybe and gets into the vertical integration in other ways, hopefully then competitors will step in and start solving those problems in ways that we didn't foresee. But we'll see.
Yeah. Kathleen and Tirzah, feel free to jump in if there's anything in particular you'd like to address. I'll just repose the question, kind of digging into what Josh was saying. Basically, if breaking up Live Nation Ticketmaster is necessary but not sufficient, what more needs to be done to promote competition in live event ticketing? What extent do we need antitrust action, further legislation, regulation, etc.? Yeah, I'd love to kick that over to Kathleen if you want to start us off on that.
Sure. So I think I would just add a cautionary note. I think it's very, it can be very tempting for important reasons to say, let's get out of the messiness of this particular case. Let's not have antitrust try to address everything. Antitrust is messy, takes a long time. There are lots of arguments for why you may want to look elsewhere to legislation or regulation to address a problem that's so entrenched. But from my perspective, it's also important to keep in mind the risks of doing that. One of the things that is great about antitrust, despite the time it takes and the evidence and the factual development and all of those aspects, is that it is very evidence based. And it is meant, the way it's done, as slow sometimes as it might be, is meant to extract all the information about the consequences of various paths, and in particular with respect to remedies. I think we're potentially seeing here, as I understand it, a separate liability phase and remedy phase, which has become sort of the de rigueur in Section 2 cases recently. So we're likely to see, I think, a separate, maybe a separate trial, a separate factual development, a separate opportunity for all the parties and stakeholders to weigh in on a remedy. I think there is always a risk in legislation or regulation that that the process gets captured, and I think that's possible. Just something that has to be taken into account whenever we turn to those solutions.
Agreed. Regulatory capture, constant issue. Tirzah.
Yes, just to kind of connect a couple dots that we've been talking about throughout. I know I mentioned the supply and demand issue with the ticketing. And I think that the secondary market actually does have a huge potential to be able to help balance that out, especially because artists don't want to price their tickets at $5,000 because frankly, it's not a great look. However, that is the price that the market can hold for a lot of artists. And so I think the secondary market is kind of emerging as a way to balance some of the supply and demand that we see dysfunctioning within the primary market space. And to piggyback a little bit on a point that Kathleen made earlier, when you're looking at remedies, and kind of like looking ahead of what this looks like. And with Ticketmaster and Live Nation specifically, we can already see them sort of laying the groundwork to try to have more control even within the secondary market. There's a lot of problems with being able to transfer your tickets out of their platform and sell it somewhere else. And so I think if we are looking at remedies, and we're looking at remedies that, I mean, I know it's okay to disagree, but maybe we all kind of agree does make sense to put within the kind of the antitrust framework within this specific case. I think really including the secondary market, and trying to come up with solutions that doesn't allow either Live Nation or Ticketmaster to kind of further constrain moving from the primary to the secondary market is a really good step, and it does allow competition to kind of come in other ways. And we can see the supply and demand changes from when tickets are first released to right before a show, and it allows consumers to make more informed decisions and have different options. And so I think that is one thing that we should consider as far as how to make it more competitive moving forward.
Thank you, Tirzah. Josh, anything else you want to add on additional remedies beyond breaking up the companies?
I actually don't think I have anything to add beyond that.
Thank you, sir. Yeah, no, I think the point that you made, Tirzah, is really interesting about the secondary markets, and I wonder, just kind of a moderator privilege. A question I have is, how does that relate to price controls, right? Because it seems as though some of the efforts to prevent secondary market abuses essentially amount to price controls. Josh was alluding to, rules that say you're not allowed to resell your ticket for more than this percentage more. So I just wanted to throw that out to the group in terms of, is there a way to deal with the secondary market without creating these kind of price controls, which can have their own unintended consequences? Tirzah?
Yes. So I think a lot of the times I want to dig in a little bit to this idea of like the face value ticket, right? Because that's generally what you buy initially, whatever it was set at. But we also have a separate kind of phenomenon that's happening that also helps balance out the supply and demand a little bit. And that's more of dynamic pricing tickets. So basically, when a lot of people are trying to buy it, the price is really high. When less people are trying to buy it, it goes down a little bit. People have different thoughts on that, but it has been shown to kind of help maximize venue capacity, which suggests that it's balancing out the supply and demand a little bit. But when you have that phenomenon happening, and then you have laws that are trying to create rules about the face value ticket, it really raises the question of, what is the face value of this ticket? If the primary ticketing platform could sell it for 10 different prices over a course of the week or however long they wait, then it raises the question as kind of why the secondary market can't do that too. And so I think there are valid concerns about consumer protections, but we can see ways to do that, such as price transparency, more security mechanisms, rules such as if you buy a fraudulent ticket, you have to be reimbursed. Some platforms offer, I think it's like 200% of your ticket. So you get your ticket money back and then some. And so there are protections that can happen that don't involve the government coming in and trying to set a price on what the value of the ticket is. Because, I mean, we've kind of seen the history of price controls, but even with ticketing, it adds another layer when you have dynamic pricing and the face value of the ticket isn't a real concept in a lot of cases.
Kathleen, anything you'd like to add?
Yeah, so I think as far as price controls go, antitrust has long said that that's not going to be the answer from an antitrust perspective. And I think that's based on the reality that if you don't have competition, it will surface in all kinds of various ways. Even if like the whack-a-mole, if you try to contain it one way, it'll just pop up in another way unless you get to the root cause, and the root cause is lack of competition. So I think the most fundamental thing you can do is ensure that there is competition and a competitive secondary market, and including, potentially preventing efforts to narrow the secondary market, for example. So, and I think just bringing that back to the idea of legislation, I would just note that one of the ways I see this, keeping in mind that competition is the root or lack of competition is the root cause of many of the problems, that to the extent that legislation looks to, and sometimes I feel like more and more we're seeing attempts to try to get some kind of antitrust immunity through, like, well, we have a legislative solution, therefore there's, or in order to get this, we want some kind of antitrust immunity, or we want this kind of practice to be condoned. So I think that it's really important not to get too invested in addressing a symptom and not and take away attention from the cause.
Yeah, that makes a lot of sense. And I think as you alluded to earlier, ideally, if we have more competition in this space, issues like bots may be solved independently by the competitors in that marketplace because, if you want to have the best ticketing platform, maybe you create the best, anti-bot software, whereas there may not be as much of an incentive to do that if you don't have that competition. Is that kind of a fair characterization?
Yeah, absolutely.
Thank you. Josh, anything you wanted to add on that?
No, only the brief note that it's another one of these things where enforcement and lack of enforcement of current laws also plays into this. A number of years ago, Congress passed the Bots Act that was trying to crack down on the use of bots in the primary and secondary markets. And really, since the bill was passed, it really hasn't been enforced all that much. And if there's one good thing that the current administration has done with respect to some of its consumer protection and antitrust enforcement in this arena, is they did basically try to commit the FTC to being a little bit more rigorous about investigating and enforcing that law that's been passed. So we'll see whether that'll give us a better indication of to what extent the whole bots problem that Ticketmaster always tries to put out there as being like, hey, this is what's causing all your problems, actually is. I think as we've all agreed, it's a lot more complicated than that, and Ticketmaster Live Nation tries to use that as a shield in a lot of cases, but it is a real problem, and so it's good to see that enforcement is happening, because it doesn't really do you any good to pass laws and have them on the books if they're not actually being enforced. Kind of the same way as this consent decree doesn't do you a whole lot of good if it's not enforced. And so, it'll be interesting to see how that plays out.
Thank you. And we are almost at the end of our event, but I did want to just give the other panelists a chance to chime in on kind of the topic that Josh just raised. How does the current administration's approach to the antitrust in general affect this case, if at all?
Well, I think so far DOJ has, under Gail Slater, has given every indication they intend to pursue the similar paths with respect to monopolization cases and cases like this. We, of course, shall see what we see. But I think that there's demand in the electorate to address these issues. I mean, this case in many ways is one of those bipartisan, everyone can find something to dislike in the way that live entertainment works. So it is an opportunity for both sides to work together and to address a problem that affects everybody. And I think the potential for positive knock-on effects from that bipartisan work is something I appreciate and would hope would catch on.
All right, we're at the hour, but Tirzah, any final words?
I won't hold people too much longer, but I just think that this case is one of those unique opportunities where there's a long history of it. We kind of know how these companies are going to act. And there's also a lot of bipartisan support. And the case that the DOJ put together is pretty straightforward. There's not a lot of novel theories of harm, not a lot of kind of newer, more creative approaches. And so I think it's a pretty straightforward thing, which I think is a nice change.
Awesome. Thank you so much to my panelists for joining us today. I really appreciate your time. I thought this was an awesome conversation. I really enjoyed it. Thank you to our participants for coming and joining us for this discussion. I hope you all found it valuable. Please check out the R Street website, rstreet.org, for more info on our work in this area and to find the paper that Josh alluded to earlier. Also, check out Tirzah and Kathleen's work at the American Consumer Institute and American Antitrust Institute, respectively. And with that, I wish you all a good day.